Hey there, this is attorney Sarah Holmes of Holmes Business Law PC. We are a business and trademark law firm located in Philadelphia and the suburbs. One interesting question we got lately was, can I register a trademark for the purposes of just leasing it back to others? The answer to that is probably not with the way it's phrased. What you can't do is be a trademark squatter. Now, this used to be a really common problem with the trademark office. They've cracked on this on a whole lot. They've instituted some penalties. A trademark squatter would really be someone that thinks of a good name and they put in a registration and then they don't really intend to use it in the first place. And then in actuality, they never use it. So number one, there is a question as to whether that application to the trademark office could be fraudulent on its face. When you file a trademark application, you have to file either on what's called an actual use basis, meaning you are using that trademark now lawfully by selling goods or services, or you can apply on an intent to use basis. Intent to use is exactly as it sounds, meaning maybe you have an idea for this name, you haven't used it yet, but you have an actual bona fide intention to use it in the future. Now, if you submit that application with absolutely no intention to use that trademark in the future, that could be a fraudulent application that could subject you to penalties and obviously result in cancellation of your application. Now, let's say that you submitted anyway, intent to use. The other issue with that is you will not get a registered trademark by doing that. You have to submit evidence of your use in order to actually get a final registered trademark. So while you apply on an intent to use basis, somewhere around 12 months after you filed the application, the trademark office is going to ask you, okay, now you need to submit evidence of your use, and in fact, you have to pay another fee. So if you can't do that at that point, you will get a couple extensions that might take you maybe 2-3 years out into the future. But in actuality, you will never get a registered trademark just by never ever using it. So there's a number of issues with trying to register a trademark that you have no intention to use. One would be potential fraud in the application issues. The other would be, well, maybe you did actually have an intent to use it, and then later on, for whatever reason, you decided not to or ran out of money. The problem is you won't get a registration through without submitting actual evidence of your use. So no, number one, don't become a trademark squatter. Don't try to register stuff you have no intention of using. And number two, make sure you have proper evidence of your use and you actually are using it in connection with selling goods or services. So, of course, if you have any questions about trademark, you need a trademark search or application completed, feel free to reach out to our office. Our number is 215-482-0285. Thanks.